Hi, good morning. My name is Chris Brown, and today's episode of ClosePoint Cafe, we have an amazing attorney that has basically found himself in a situation where he has now become one of the foremost real estate attorneys in the state of New Jersey. From doing simple transactions, residential transactions, to processing major, large real estate developments in the state of New Jersey, while also representing a bunch of different towns as the attorney for the planning boards. So we're very lucky to have with us today Mr. Jay Weiner. Good morning, Jay.
Thank you, Chris. It's a pleasure to be here.
I'm glad you're here with us. So Jay, talk to us about how you got started as an attorney. You know, how did you go, where did you grow up, and what led you down the path to become an attorney?
Sure. Well, I went to undergrad at Rutgers and really wasn't sure at that point if I wanted to go to law school. I really didn't make that determination until later, a latter part of my undergraduate time.
What was your major at Rutgers?
I was a political science major.
Okay, me too.
I really, I liked politics, I liked history, and I was still kind of finding my way, on the liberal arts side with all of that, and to figure out what I wanted to do. And then ultimately I decided on law. And fast forward through law school, my first job, I worked for a firm that did primarily insurance defense work.
Oh, wow.
I was based in Jersey City. And after a couple of years of doing that, I decided jointly with my brother, unfortunately he's no longer with us, but although he was 3 years older than me, he was a year ahead of me law-wise. Okay. And we decided we were going to try, while we were still relatively young and independent, to try to start something ourselves. And we went into practice ourselves with basically a couple of nickels to rub together and not much in the way of clients. And that was in 1996, and we pretty much started from scratch, hustling and picking up work where we could.
So your brother, what was he focused on as far as, what would you say his forte in the law was? Well,
initially, we shared everything. He did a lot more of criminal work, felony criminal work. I did a little of it, but not as much as him. We both shared in the real estate. I did more of the personal injury side, and that was kind of our balance. And then there was overlap. A lot of the things we would share, a lot of files we both had our fingerprints on. And, and then as we kind of defined our roles more, not just our individual roles, but the role of our practice, where we wanted to go, we became much more real estate centric.
Okay.
And the criminal work kind of faded after a while. It just wasn't something that we chose to continue on in a significant way after a few years. And that was kind of the general direction of which way we went.
So growing up, were you and your brother close?
Yes.
You were?
We were the only two siblings, and we were 3 years apart. And we did, other than me being the runt and not, chased away by the older brother sometimes, but for the most part, particularly as we got older, we were extremely close. We were best friends as well as brothers and eventually law partners.
And where did you grow up? What town?
Well, we grew up originally in Staten Island.
Okay.
Our family relocated to East Brunswick when I was 18, and that would have made my brother about 21.
Nice.
And I've been in that, other than for law school, I've been in that general central New Jersey area ever since I'm 18 years old.
And you went to law school at Toro?
Toro, yes.
So, because my cousin went to Toro also.
Okay.
And he's a district attorney for many years in Nassau County. But now he's in private practice for criminal also. So that's when I saw that you went to Toro. I was like, oh, my cousin John went there also. Yeah. So good law school.
It is. It's a strong regional law school. And I'm proud of the school because I've seen the growth in a positive way over the last several decades.
Cool.
A larger campus, they relocated to much bigger facilities and so forth, and it's really developed a nice reputation.
So your brother, he passed, you said?
Yes.
Do you mind talking about,
No, not at all.
What was his, how did he pass? I mean,
well, unfortunately, when he was about 42 years old, he was kind of suddenly, without much prior notice or warning, was diagnosed with colon cancer.
Oh, geez.
and he fought it strong for about 2 years, and then eventually he succumbed, unfortunately, to it.
Wow. I'm so sorry.
Thank you.
So you and your brother built this practice. He unfortunately passes. What was it like for you? What did you say? Okay, now I got to get a hold of the reins here. I mean,
I was curious. I went through a couple of different phases.
Okay.
The first phase, when he was first diagnosed, part of the issue was that the natural division of labor in our practice was, my brother was, for those, and you know him a little bit, and for those who knew him well, he was much more of the, not that I'm not, but he was much more of the gregarious, outgoing type of person. He was very much the type of guy who could go out, and he was very good at networking and drumming up business and things of that. And when I was younger, I was still a little bit more introverted.
Okay.
So the first thing I had to do was, when he was not well, is I had to redefine myself personality-wise to take on that role, which at the beginning was not something I was naturally comfortable with. And it took a lot of work to really focus on that and build my skills on that way. That was the first step. And then after he passed, it was just a matter of balancing what had long been the work for two people. And I would say after he passed, it was before he passed too, because the second of the 2 years that he was in his battle, his work and his ability to be at work obviously was diminishing. I really did a lot of introspection on myself and reflected as to, what type of work do I want to continue doing? What type of work do I enjoy? And what type of work do I not enjoy? And I tried to gradually redefine the focus of the practice of what I'm dealing with.
Gotcha.
And what type of work I want to do and what type I don't want to handle anymore. And I gladly steer clients, if they call me, to someone who does that type of work, but to limit myself.
Gotcha.
Excuse me a little bit. And that's kind of what I did. That was the next step. And that kind of led me down the path more towards one of the areas that I do a significant amount of work in now, which is in the land use and zoning and planning, in addition to more traditional real estate transactional work. I always enjoyed that area, and I just kind of focused my energy in trying to see what I could do to network in those areas and try to be fortunate enough to receive business in those areas as well, which took a lot of work and time to do.
Always does.
Yeah.
But I will ask you, so your brother is like the marketing guy,
Yes.
going out, pressing, hands, and just being who he was, just a good guy, where people just enjoyed, working with him. Would you say that he taught you how to become out of your shell, that you were saying this, the introvert aspect, into what you are today?
Yeah, indirectly, yes.
Okay.
I mean, it wasn't like we had conversations about it, but
by being with him,
I modeled things after him. I kind of, the good and the bad, and I saw some things that maybe he did that I didn't necessarily care for that approach, so I left that out. But anything that I thought was positive, I basically emulated and said, you know what, it worked for him, this is what he did, I'm just going to start doing that, and I'm going to just redefine my personality. And even today, when I meet people, whether it's professionally or socially, if I tell them that in years past, up until, say my brother passed 15 years ago, if you go back 15, 16 years ago, beyond that, I was not really what you see today. I was much more quiet and a bit shy and things of that nature, and that's really gone now. It's kind of been a personality change that was forced upon me, but I'm happy for.
I have to say, I am surprised by the introvert side, because I've seen you in action with your clients, and they're so comfortable with you. They enjoy speaking with you. They feel like they're getting really good advice, and they have competent representation. So that's, I guess, a credit to your brother and you.
Thank you.
You also touched on something that I've been harping on. you decided to do work that made you happy,
Yes.
not frustrate you. Not That's really interesting because a lot of people, they look at the dollar as, going after that money no matter what, even if they're miserable, and it's not worth it.
No.
It's never is. But yet you decided in that moment, because you could have done anything you wanted. I mean, you could have stopped the practice too.
Yeah.
But you decided to say, you know what, I'm redirecting my energies on things that make me happy. And because of that happiness, would you say that you're more successful now than before because of the fact that you're doing things that you enjoy doing?
Oh, absolutely. I think it's all interrelated, and to be successful, in my opinion, you have to have a passion for what you're doing.
Absolutely.
It can't just be a job. If it's just work, then you're just going through, I don't want to say you're going through the motions, but in a lot of ways, it becomes routine.
Right.
And when you have a passion for something, you look forward to it. And that's what I felt I wanted to develop. When I was younger and there were two of us working together, part of the passion was the enjoyment of working together. Every day we'd get into the office and we'd brew a cup of coffee and shoot the breeze about what transpired over the night before, whether it was our sports team or what was in the email that
Family
we had to deal with,
whatever.
or family. Exactly. Right. That was gone. So then I was left with, all right, it's only work now when I come into the office. And of course, I have my staff and my current person who's been with me for 17 years. I mean,
let's give her a shout out, Tammy.
Yeah, Tammy is like
amazing.
I tell her, she's my sibling from a different set of parents, and she says the same to me. So,
and talk about an incredibly strong person.
Yes,
Tammy's amazing. I mean, she's competent in what she does, and she has her battles. And,
yes,
and she's overcome those battles and maintained the productivity to her.
Yes,
which is insane to me.
And she's a one of a kind person, and has my back, and couldn't have a better person. Even though it's my law firm, it's easier for me to say I have someone who works with me rather than works for me, because to me, she is very much so integral to the practice. And so what I was circling back to is the idea of having the passion for the work.
Right.
And I just started saying, I don't want to handle things anymore. And I mean, I don't want to necessarily go through a list of things I don't want to do. But there were certain things that I did some occasionally, not as much or whatever, that I was just like, I don't want to handle this anymore.
Right.
And so it's all right. I have the work. I'm going to do my best, of course. The active files, we're going to continue as hard as we can to work on them and get the best results for every client. Mm-hmm. But when the new client calls on the phone and says, can you handle A, B, and C? The answer is we're no longer taking on those types of cases. I'll gladly give you the name of a couple of people who I'm familiar with who might be able to help you. And that's it. And that's kind of how I steered myself. And what I've also tried to do with that is a lot of what I do, with the exception of, I do all types of civil litigation, and I would say with the exception of personal injury, which is kind of a little bit of an overlap to employment laws, where wrongful termination, things like that. Those are kind of their own little category, but everything else that I do, all is kind of woven together.
Okay.
If you take real estate transactions, I can give you an example if you'd like.
Go for it.
Okay. Someone calls me up and says, making a hypothetical, I'm a dentist and I want to buy a piece of property. I'm going to build an office, and it's going to be a small building, and I want to have an office, and I want to have maybe commercial or a business, or office space or something in there, maybe residential, some type of mixed use.
Right.
What can I do? Well, where do you stand? Right now I'm buying a piece of property, or there's an old building on it. We want to renovate it, convert it. So I'm handling a real estate transaction. I'm then, if they're buying, sometimes they may be buying an existing practice. which then comes in, they're buying a business.
Business, right?
So it becomes not just real estate, it becomes a business transaction. And hopefully, I mean, for small businesses, I found that usually asset purchases are better than stock purchases. So I'll roll with that and say it's an asset purchase. So you have to deal with those issues. Then it could be contingent, or if it's not contingent, after the closing, upon getting land approvals to go before municipal boards to, you want to do your changes. Do you need zoning variances? Do you need a use variance? Or if not a use variance, are there bulk issues if you're changing the property? All of those things, site
really
planning issues. There's various things that come up. So suddenly you could throw, and then other things happen. The business could be a franchise. Right. So you're talking about transferring a franchise. I've done where there's some people are buying like private schools. There's licensing issues that they have to be involved with the state. So suddenly 1, 2, 3, 4, you have 5, 6 elements that are all rolling together from one transaction where someone says, I want to buy a piece of property to go put my dental office in or something of that nature. And that's kind of an example of that. So you see all of that, and then you're the attorney, hopefully, for that client if they're satisfied with your work. And when other issues come up, which I do a corporate practice, people come back. Can you prepare a contract for this? Can you handle this for me? Or I need
an operating agreement.
An operating agreement for an LLC, or a restrictive covenant for a new employee, or a confidentiality agreement, whatever they may be. Or sometimes there's litigation involved with another party, and I need someone to represent me in court. And all that type of business and commercial litigation comes into play.
What's interesting what you're saying is, because I've dealt with so many different real estate attorneys, and they're so specialized, they'll only do residential. But when it comes to a business asset sale, they pass it on to another attorney. Mm-hmm. So now I'm dealing with 2 different attorneys, one for the real estate side, one for the business, which is fine. But with you can handle it all.
We try to, yes.
Well, I've been part of those deals where you've done it all, and you've done it well. And that's why you're sitting here today, to be quite honest with you.
I appreciate that.
I mean, I remember the IHOP deals, that were complicated, dealing with the franchisor, and all the different, requirements, and I learned a lot from just watching your emails go back and forth with the, either with the franchise.
What's curious, though, I find, and I understand what you're saying, that some don't like to mix the business with the real estate. To me, what's curious, and this is where I find the use of the title company, and this is where we work a lot together on these deals, is for due diligence. You see so many people want to buy a business, and they do their due diligence, and they're studying all the financials and the business aspects of the books and the customers and the flows in and out and so forth, everything they need to do to see if the business is viable on their due diligence. But one thing is that I've actually astonishingly have seen is sometimes there's a lack of due diligence for the part of making sure the asset they purchase is secure and is not encumbered.
Right.
And we work on them a lot together. We do business searches and
UCCs.
I can tell you
judgments
recently, and this is a true story. I was representing a seller in a transaction who was selling his interest in a business to a partner.
Okay.
And we spent 3 months negotiating the contract.
Okay.
Finally, when we negotiated all the final terms of the contract, we signed everything. Everyone signed the documents. The same day, the buyer and his attorney funded the transaction and said, we're closed. And that was it. And I sat there to myself and said, okay, I mean, contractually, they're all protected. There's indemnification and so on and so forth. Now, unless they did business searches and didn't show them to me because they were satisfied with them, I can't rule that out. But usually the course is you get your contract, then you have a time to set a closing date, and then do that's the primary reason to do your due diligence. Make sure there's no judgment out there. I don't want to have to come back hypothetically as a buyer's attorney and go pursue someone because I found out there was an unsecured loan out there and no one did a UCC search, or there's a judgment against the guy. Yeah, and even though there's indemnification, if I could have straightened this out beforehand, or is there pending lawsuits?
Or their corporate filings are on time, because one could be a tax matters partner, the other one was just a passive investor. They're not really involved in the tax, filings, and they didn't pay their state franchise tax or
exactly.
Whatever,
those are the things. To me, there are basic things. The franchise taxes, particularly when we're dealing with asset purchases,
correct,
and the also judgments, litigation, and doing UCC searches at the county and state level. And forget that one example. I've actually, years ago, thankfully not in a long time, but I've had attorneys call me up and say, I'm not too familiar with this. I'm representing someone who's buying this business or whatever. What do I do? And I'll tell them, here's a checklist. Go through these things. And they'll say to me, thank you. I never would have thought to do those things.
Right.
And it's not that I have all this expertise like it just came into my head. And I think of myself as a sponge. I always want to absorb more. I always walk into a room thinking I'm the dumbest guy in the room. And I'm always keeping my eyes and ears open to learn, see what I can learn, something new.
Which makes you the smartest guy.
And that's kind of it. It goes back, I was a kid. We're the same generation. When I was a young kid, I used to like the original Star Trek episodes.
Yep.
And if you remember, Captain Kirk would always ask a million questions and be the antagonist. And Mr. Spock would always stand at his shoulder, observe, listen, and never say a word. Then when they were alone, Spock would give him all the feedback. And it was a set type of approach.
Sure.
So I take to, since I'm by myself, I tend to take the Mr. Spock approach of don't talk, listen. Yeah. And you learn more. So how do I learn? First of all, I'm never shy to ask a question. If I take something on and I'm not familiar with, I will call the people I trust and reach out to and say, hey, what do you think about this? And we've done that exchange back and forth.
We play devil's advocate against
what about this? How about that?
How do you handle that? Right.
And run it around, because two minds are better than one mind. And it's the only way you learn. I tell my children all the time, my son is 21, my daughter is 17. And I tell them all the time, every day, by the time you go to bed at night, if you can say that you learned one new thing today, it's been a successful day. It doesn't have to be monumental. It could be very small, innocuous, immaterial. But if you can say, I learned one new thing, it could be useless trivia.
Right.
It made you in a little way brighter, more intelligent, more knowledgeable than you were when you woke up in the morning. And that's life and growth. And it applies to business. It's the same thing.
If you sit in a shell, and don't put yourself in an uncomfortable position, just like you did when your brother passed.
Yeah.
You forced yourself to become the rainmaker for your firm, but you did it also on your terms that made you happy.
Yeah,
which is super cool, because it doesn't happen a lot.
Yeah.
So now today, I was reading your bio and I was like, holy crap, you're all over the place. How many towns are you representing right now?
Well, right now I represent 2 towns.
Okay. But in your past, you've...
you know what? A lot of what I've done is those are my towns that I have the contracted attorneys for. Is East Brunswick, which I've done for several years, the zoning board, as well as East Windsor, the zoning board.
2 very active towns.
The other towns, what I've done is, because it's a small community of land use attorneys, is over the years I've been able to cover and fill in and substitute for a lot of other attorneys on matters in various towns all around, mostly Middlesex County, some out of the county, but in various other towns where I've had to fill in.
Right.
So that's given me a lot of perspective, even though it was a part-time thing, on occasion, it allowed me the time to just get involved, see how other boards do things. Every board does it a little differently, because in local boards, the board is the kingdom. And so you get an idea of
All the
learning
growth happens in a town.
all of the little nuances of how each board works. So
Right.
yeah, I've had an opportunity to do time in different towns, helping out other attorneys on for when they couldn't handle a meeting or they had a conflict or things of that nature. And that gave me a lot of experience as well. And I also do the applicant side. I don't just do the
Right.
the board side. So that gets me around the state. Yeah.
So let's talk about that process, because a lot of people watching, and a lot of investors, real estate investors, jump on this podcast. Talk about what it takes and what your little pro tips are to get a major site approved. Let's talk about 15 homes, single family homes in a town. What do you tell your clients? This is what we need to focus on.
Well,
and what are the keys that they need, professional wise, to get through that process? Because it's a gauntlet. Mm-hmm. It's a gauntlet in New Jersey.
It is.
And it's expensive as hell. So if you could.
I think the number one thing for any type of land development project is you need good engineers.
Yes.
Who really know that area of engineering, dealing with development. That's key. Mm-hmm. But I think what's primary, the bigger your project is you need to do more preliminary work. You want to try to set up a meeting, sometimes before even filing an application, just with the professionals in the town, the planning and engineering people.
How do they get a hold of those people? How does someone get a hold of those people?
You can call them up usually and just contact them. And
go on the website, see who's the appointed
engineer.
Or
the old-fashioned way. Walk into the building.
Okay.
But go in and try to set up and talk. I tell every client, even on something small, I said, before they'll call me and they'll say, I'm buying a property and I want to build X, Y, and Z. It's contingent on it, or it's not contingent on it. What should I do? I said, before we even sign a contract, go down to the municipal building, ask for the zoning officer, tell him this is what I'm thinking of doing, mm-hmm. him or her. I don't.
Sure.
But tell the person this is what I'm thinking of doing. Introduce yourself and get a sense of feedback. Now, the reason for that is when you apply, you want to build something, you want to do this, the first person you have to go to is the zoning officer.
Right.
You need to get a zoning permit. He's going to say either you're zoned for this, it's permitted, or you need to go get some type of variance or approval for this if you need variance relief. So start with them before you even sign a contract. See what they're looking at. Of course, the board, the zoning officer can't tell you ultimately if you need some type of approvals. He or she can't tell you what the board's going to do.
Right.
That's impossible, and it would be inappropriate. That's the jurisdiction of the board and only the board. But you can kind of get a sense sometimes, hey, you know what? I'm the zoning officer, and although you need relief from the board, maybe this fits our scheme. We have an overall plan in the count, or what, or you got to get feedback. And right. Those are the things that it's important to just meet and understand what's going on with that. So to me, getting in there first, I've had deals die, but in a good way for clients, because they'll do that.
Yeah.
We'll sit on the contract and attorney review.
Didn't pay that retainer for an engineer.
A week or two later, he's like, this isn't going to work. Well, why? Well, because I sat with the zoning officer and they gave me a map and half the place is covered in wetlands, which I didn't know. So I can't develop there. Okay, well, now you didn't have to spend who knows how many tens of thousands of dollars on engineering to work it up to do this, because you walked in the door and you just met with someone who knows a bit about the property.
Right.
So I think gathering information preliminarily is a number one concept for that. Also, when you do that, you can find out if there were any other similar applications for the same land when you're going in there. Well,
that's a good point.
Someone else bought this and it fell through. Why? Well, did it get to the board? Was it denied? You can go pull a copy of a resolution, find out, do your homework and find out maybe why something didn't take.
So part of the due diligence, prior to even signing the contract, I just want to break it down for everybody. Go meet with the municipality.
Yes.
And then also file an Oprah request.
Oh, absolutely.
And on everything that pertains to that, particular lot and block that you're, looking to develop.
Yes.
Okay, and then once you get that information, you can, without spending a dime,
Yeah, exactly.
without spending a dime, now you know if you got a viable deal or not.
Yeah, why do you want to do your due diligence portions that's going to cost you money when you can do the free or very inexpensive, modest cost for an Oprah request or whatever and get as much information? That may be your threshold information.
How
that
many
determines
people
it.
miss that step and they go right into a contract is mind-boggling to me.
They miss it in residential real estate too.
Yes,
if
they
I
do.
could segue to that
Go
for
for
a
it.
brief
Yeah, absolutely.
sign. In residential, and I don't want to use, everyone talks about permits, and that's always an issue. It's a legitimate issue. But there are other issues as well in residential real estate, and you should always, I tell every client, although it's not something that as part of me in residential real estate do for them, but I put it out there for them very clearly when they retain me, that I urge them to go do an Oprah request and gather as much information they can about the property. And you'd be surprised what turns up. And I have a matter now that's ongoing where a seller indicated that there was an underground storage tank
Okay.
previously removed by a prior owner. They didn't have any paperwork. So I suggested my client, strongly suggested, you need to go and do an Oprah request and get a full copy of the entire township's file related to any underground tanks. And in addition to everything else, so you want to get a full permitting history. I always recommend they get a full history from the tax assessor's office, and also a full history from planning and engineering. You want to know if there's any applications pending within 200 feet,
Right.
things of that nature. So that's kind of a good starting point. And then if you feel you need more, you go back and ask for more. So what happened is the client came back. It took a week or two because we didn't just want a spreadsheet.
Right,
We wanted the documents.
The documents.
Okay? We got a package. It was several pages thick. And what we found out was that the tank was not removed. It was decommissioned and left filled and left underground, which is no longer favored
Right.
in New Jersey. So we then told the sellers, we need to remove it. And the seller said, well, we don't know where it is. Do a scan, and then we'll take it from there. Well, we couldn't. They did your conventional scan with the magnet.
Right.
They couldn't find anything.
How about that?
They had to come back a second time and use ground radar. Then they found it. And the tank was full. It was filled. There was a permit for it, that it was properly closed and so forth. And then we said, all right, you have to get the tank removed. And my preference would have been not to close until everything was done. However, both parties had urgencies unrelated to that necessitated it to close.
And they held an escrow.
Hell of a net escrow was putting it lightly, because
What's like an escrow for that?
for that, I think, I don't know, I would say somewhere in the $50,000 range. But you have to be careful with the escrows. No matter what the range is, it can't be a cap,
Right.
because you just never know what liability could be. So the cost probably to remove the tank and so forth, it might have been under $10,000. I don't know what they cost. I could be ballparking that. I don't really recall, but it's not astronomical. The basis for the escrow is on the rare occasion if they pull that tank out and there's contamination.
Yeah.
And everyone always says when you first proposed the big escrow, but it was closed properly. There were permits.
Right.
Well, you know what happened? They pulled the tank out.
Okay.
And there was contamination. And so now they're in the process of getting a no further action letter from the DEP, and it's all coming together, and the escrow is more than sufficient to cover the amount.
Good.
But without doing the Oprah requests or really following up and doing the due diligence, that's just going back on a residential property. That could have been a very big problem that runs with the land. After a buyer owns the property, it
That's
runs with
their
the
issue.
land.
Yeah, and a lot of people don't realize that. They can't go back to the seller.
Exactly.
They can try, but it's not going to really go anywhere because the DEP is coming after you.
Exactly.
To make good on clearing this land.
Yeah, and as we all know, in real estate, everything generally merges with the deed unless we agree specifically to have something survive it.
Right.
Or there's something tantamount to fraud, whether it's legal fraud, equitable fraud, some type of intentional misrepresentation, non-disclosure. Those are very hard to prove. It's
Right.
a clear and convincing evidence burden. It's not even a preponderance. It's extremely hard to prove. You need a lot of evidence. So good luck with that.
Right.
If you have to go that route, that's the last alternative, not the first alternative.
So now they do the Oprah request. Okay, the land looks good. They enter into contract. They've got a time period to let's talk about a major subdivision. They have a time period to get an approval. What do you recommend when you're representing the buyer? The time period of approval that you want in your contract.
Yeah, that's tough.
I know it is.
It depends really on the project. You say major, you could be a major subdivision of 10 homes.
Let's say 10
okay,
homes.
Or it could be 200.
Let's say 10 homes.
Okay, so I would think realistically, and this is again why it's important to have a good team, because I need that coordination with the engineers to kind of get an idea of how long if we're going to have a contingency to get the approvals before we close. I need to know from the engineers a good idea when they're going to be ready to have their work done and completed and submitted. So otherwise, I'm picking numbers. I may go maybe 90 days, maybe 6 months, maybe a year.
Based on your vast experience, when I come in or any developer comes in and say, hey, Jay, how much time, in East Brunswick, do you think we should allot in the contract for me to get my approvals?
I would think, just knowing what needs to be done to get it to a board, I would think no way under 6 months as a floor.
As a
floor. I would prefer 9 to 12. Right. Not always can you get it. It's a negotiation. The seller may not want to give you that much time, but you get what you can negotiate and you work with it. But you want to get as much time as you can.
Sure.
And even then, that's to get your approvals, but you have to have other protections in there. One is that's your time limit to get approvals. You maybe try to negotiate extensions, whether they're automatic or may not unreasonably be withheld. You can even do, if you want, sizable extensions. Maybe there's a financial benefit to the seller, like on an option to extend the time more, and you'll pay them more money if it gets approved. There's all different things. It's always open for negotiation. But on the back end is you don't want to close, not just once you get your approval. That's one contingency. It's like doing your home inspections on a residential deal. You got 14 days or whatever to do your inspections, but you're not closing on day 14. If there's a problem, they got to do repairs. You got to get your title done. You got to get your mortgage done. Then you first close. Same thing here. You get your approvals. Understand most boards, a major resolution like what we're talking about, that resolution is not being done the same day as the board votes on the approval. It's not. Some towns, maybe they have a quick resolution when someone's putting a fence up in their backyard, and they'll approve the resolution the same night. Although I haven't seen that in many years, and it's not something I, as a board attorney, have ever done. But I've seen that in other towns. But on a major resolution like this, the resolution is going to be prepared after the fact, come back at a next meeting, and there's a time limit under the municipal land use law that you have to prepare your resolution and it has to be adopted by. But it's a significant amount of time. And even then, if it's not done, all that means is that if the applicant wanted to, they can go to court and force an adjudication of the resolution. But the bottom line is it takes time to get the resolution. And then if there's any litigation that can come about from that, so you're assuming you're approved, but if there's a third party action, someone who opposes your application, they have what's called, it's a prerogative writ action.
That's right.
An action in lieu of prerogative writs is the correct legal name under the New Jersey court rules, and they have 45 days from the date of publication of the resolution to file a lawsuit.
Yeah.
So ideally, the way you want to have your closing date is you want to, at the earliest, be at least I always go about 60 days,
Yeah, I was gonna
but
say.
you want to let that 45-day
90
period
days
pass.
is
So,
probably the...
so I would say at least 60 days after the publication of the resolution. So, they had 45 days to file. If there's any quirks, anything going on, there's an extra 15 days cushion, and then you should be ready to close. And again, it depends on the contract. I've seen some where they don't close until all the conditions of the resolution are satisfied as well, which could be, outside agency approvals, whether it's from freehold conservation or the county or wherever it might be that falls into play. In other towns, it could be Delaware and Raritan Canal, or it varies from county to county and region to region. But there are outside agencies that may have jurisdiction on the issues.
So to break it down for everybody, you have to get an approval from a municipality.
Yeah.
You have to get approval from a county. And if your property, let's say in the Pinelands, you have to get approval from the Pinelands. And then you have to worry about DEP approvals. But usually DEP will fold into the Pinelands under their engineers. That's why New Jersey's so expensive.
And that's where I
People
mentioned...
don't realize the monumental task of developing in New Jersey is today.
That's why I mentioned the DNR Canal, because
that's a big one.
In addition to doing board work professionally and legally, I also sit as a citizen member on the planning board in Monroe Township.
I didn't know that.
And years ago, when I was an East Brunswick resident, for many years I sat on the planning board there. And what I've come to learn is in Monroe Township, one of the outside agencies that occasionally may have jurisdiction is the Delaware and Raritan Canal. And as a planning board member, I'll see that. And that's not one that I've seen in recently. I've seen it before, but it's not one that comes in every town. It has to be one where the canal runs, touches on or runs through or is somewhere in a way related to the watershed. And so you see all these different quirky things. Up north, there's different...
the Highlands Act?
Exactly. The Highlands Act is one. And it's all kinds of quirky things that you just don't know.
It's expensive. It's long. It's hard. Putting up the sticks and actually building the structure pales in comparison.
That's often the easiest part.
It's the easiest part.
Yeah.
That's like, that's easy. You can put a hammer to nail, but which I thought was, but no, getting the approvals. When I've gone through myself on various projects, I was just amazed early on, and I'm talking maybe 15, 16 years ago, the amount of little nuances that can trip you up.
Yes.
In these things. A lot of people don't even realize the multiple boards within a municipality. The planning board, when you have a conforming lot, would go through the planning board. You're not asking for any relief. Then the zoning board. Now, some municipalities, I don't know, East Brunswick, does it have a land use board that covers both?
No, East Brunswick, the larger towns
Have to.
usually have two.
Right.
Smaller towns have
Land use
one board.
Yeah.
Either they call it the planning board or they call it a land use board. Theoretically, I think based on statute, it should be called the planning board, but they could sit as a zoning board when the zoning issues come up,
Gotcha.
like a D-variance. But it's one board. And the big thing there is when they're sitting as a zoning board, the mayor or mayoral designee and the governmental appointees can sit statutorily on a planning board are disqualified and they don't participate when it's a zoning board.
Gotcha.
So in my area, a couple of towns that sit as a single board, the borough of Helmetta is one that comes to mind. And if I'm not mistaken, I want to say that I think starting this year, the borough of South River is switching to a single board from two boards.
It's funny you bring that up. I was just on the phone with the tax collector of South River.
Yeah, and so don't quote me on that one, but I think that's what I've heard. I don't have anything pending right now in South River, so I'm not 100%. But I believe that's what I heard, is that they're switching. So you just never know.
So you need a really good engineer that communicates with your attorney. The attorney needs to be able to gauge the time frame on basically their experiences that they've had with other applications. I've gone through that town. So it's very prudent for a developer to make sure that they have an attorney that is aware of what those towns' procedures are.
There's a few other things you need too in there.
Yeah, go for it.
Yeah,
I wanted to cap. Like,
No. Aside from the engineer is your leadoff hitter.
Right.
Okay. You're also going to need.
I love the baseball analogy, though. You know me.
Yeah, I know. So the engineer to me is your leadoff hitter because you got to start. Who's the first person you're going to reach out to is your engineer. But at some point, when you're getting through your engineering, depending on how far you're going, if you're bifurcating or you're going for one approval, you're going to maybe need some architecturals.
Right.
So you're going to need to have an architect. And
by the way, the architecturals, you're right. That's a really good point because I've sat on planning boards. I've appeared before planning boards. I've always liked the the renderings.
Yes. People want to see what it's going to look like.
What it looks like.
Exactly.
To give a vision of what you're trying to get approved, not just these boxes that are on the plan. That's a really good point.
Yeah.
So an architect
So
is
architecturals are important, and a
he would be your second hitter.
Usually, you go with your engineer. You go, you can see how you're presenting your case. Your leadoff hitter is your engineer.
Right.
They do the heavy work. They get it going. Your architect can then come in, and because that complements the engineering. Engineer is going to show the whole layout, what's going to be done, where it's going to be built, how it's going to be built. Then the architecture is going to say, this is how it's going to look.
It's how pretty.
This is the layout on the inside, because the architect does the interior layout, as well as you want to see the facades and the materials, and those are things that go into consideration. So that's good number 2. Number 3 depends on the type of application, but if it's an application that warrants it and you need a traffic engineer,
that's right.
That should be number 3. If it's a small application, you may not need it. Again, that really, you're going to get that feedback from the township, because once you fill out your application, you're going to get feedback from the township's engineers, and they may raise questions, and that may require you then to bring in a traffic engineer, or you may know from the outset, based on the nature of your project, that if you feel there's going to be an impact of traffic, you need to have the proper studies done to show the board that it's not going to be a burden that's going to prevent you from receiving the relief that you need.
Or if a traffic light has to be.
Yeah, or something, exactly.
Or traffic calming devices.
A plan needs to be put in place to attenuate the problem.
It's like triangle easements, all that.
All of those things, exactly. So that could be number 3. And then the cleanup hitter generally is, particularly if you're going for a use variance of any type, your cleanup hitter will always be your planner.
Right. Well, let's define planner for people, because some people think your engineer is your planner. It's
correct.
Not.
It's not. Yeah. So a planner is a totally different specialty. Licensed professional planners, and they are, in a lot of schools, they still call it urban planning.
That's right.
As a major.
They do.
Although it's not just urban planning anymore, it's all over. I'm proud to say that my son is a senior right now at the Blaustein School at Rutgers University studying planning.
Yeah.
And so what a planner does is, I guess the best way to think about it this way. And I say this in a very shorthand, I'm not diminishing anyone's roles.
No, go for it.
A planner is maybe the one who is going to come up with the concept of, you want to develop this whole area of the town? I think the buildings should go here, and the stores should go here, and the road should go here, and the turnoff should be here, and we should have a park here, and maybe the school here.
Or a residential, or is it going to be a cul-de-sac?
Yeah, a cul-de-sac, or exactly, or is it going to be a circle, or whatever it might be.
They're looking at the aesthetic of the community from
the overall plan of the community. Yeah. Okay. Then the engineer is going to go through, how are we going to build this? Yeah. And then the architect is going to say, this is how it's going to look.
Right.
So you need all 3. And planners will actually, I think a great example, if anyone is familiar with the Renaissance Center in Detroit. Okay, that's the GM Renaissance Center. Okay. It was built a good few years ago as GM's world headquarters. And it's a series of beautiful skyscraper buildings
I've seen pictures.
right on the Detroit waterfront. The concept of the Renaissance Center and then the development of the area around it are concepts that are put together by planners. Then once the planner comes up with the scheme, the engineers say, okay, how are we going to build this? And then after the engineers say, this is how we're going to build the buildings, the architects say, okay, we're going to take over now. We're going to show you how this building is going to look, and it's going to be beautiful, and we're going to do the layouts of the interior. Right. So you can't have them all. But now, why is the planner the cleanup hitter? Is when you're looking for approvals for variance relief under the municipal land use law, you need to have expert opinion to show that the criteria under the municipal land use law have been satisfied. And the person who can testify to that when you're dealing particularly with a use variance is a professional planner.
Okay.
They're the expertise, because it's a planning heavy burden that you have to prove. Okay, you have the positive criteria. You have to show it as a benefit. I'm not going to read the whole statute.
No, I got you. Yeah.
You have to show positively that.
Yeah, it's not going to be a detriment to the community.
Well, that's on the negative side, but the positive is you're advancing a goal of the municipal land use law, or so on and so forth. And then the negative is you don't want to make sure there's no negative impact, no negative detriment, A, to the public, and B, to the zone plan and the zoning ordinance. So when you're talking about zone plan,
but those detriments are not just physical; it could be environmental.
Oh yeah, it's,
all those things.
Anything.
Right.
And what is the zone plan? The zone plan essentially is the concept. It's the master plan of the town.
Right.
That's all within the jurisdiction of the township planner.
Right.
They're the ones who put that together for the township, and therefore, as an applicant, if I want to show that I'm meeting all of these criteria, positive and negative, I need to put a planner up to give that testimony. And that's why the planner is not just necessary, but is always the cleanup hitter, because the planner has to integrate all of the other testimony of your other professionals. Okay. Usually, a good planner and a good applicant and a good teamwork concept, your planner is, even if you're going to more than one meeting, your planner is going to be at every meeting, sitting in the audience, and listening to your other professionals.
Gotcha.
And if the planner can't make the meetings, you're going to hopefully get them a transcript, because they want to be able to, by the time they go and do their own testimony, they want to reflect back and say the reason we satisfy all the positive criteria and the reason we satisfy the negative criteria is because you heard our engineer talk about this, and you heard our traffic engineer talk about this, and our architect discuss this. Right. And all of those different things come into play for the planner to give an opinion, because it's a balance test to say that I feel the positives outweigh the negatives and so forth, to allow for an approval to go through to convince a board that they should grant an approval.
Gotcha. Now, as the attorney, where do you hit in the batting lineup?
As an attorney, it's very similar to anyone who does trial work.
Okay.
I give my opening argument. I call and direct the witnesses.
So you're the manager.
Basically, you're the ringmaster.
Yeah.
And then I'm going to do summation. And the rules of evidence are very informal before planning and zoning boards. But it's essentially almost, if you want to say, it's a loose trial. And I say loose, not to demean it, but only as a matter of, because the rules of evidence aren't as tight and as strict. They're loosely interpreted. So as the attorney, I'm the manager of everything. I got to make sure everyone's ready to go, everyone's in line, review everything with the witnesses in advance, make sure I understand what their testimony is, go over with them maybe points that we have to make sure we hit stronger than others, and all of that, and get the whole team together.
And the best attorneys I've seen that process or do what you do exactly what you're talking about beforehand.
Yes.
No surprises. They don't want any surprises at the meeting. They want all their concerns bottled up and answered for when they're standing there. And presenting the case for the client.
I remember one meeting a while back.
Did you go nuts to the time?
No. The applicant was making their counsel was making a presentation, and they finished, and then the meeting gets opened up to the public, and all of a sudden someone comes up to the microphone in the public portion, and it's the applicant. And their attorney he heard the voice, and he gave, like you saw my head look like this. I'm emulating. He kind of did a side eye and did a quick look. And he was like astonished because he had no idea his client was getting up in the public portion to speak on his own.
That's a new one.
Yeah. So you just never know what's going to happen.
And that's something that should have been discussed beforehand, because all your engineers and everything don't want to contradict what the applicant wants.
Yes.
In any way.
It didn't. For him, and fortunately, his client didn't do anything that was detrimental to their own application.
Right.
But I remember chatting afterwards with the attorney after the meeting was over, and him saying, "I had no idea that was coming," and thankfully, it had no bearing on their matter. But
so interestingly enough, my son Brian's going to law school.
Yes.
And he has taken a real liking to of course, residential or real estate from a residential standpoint, but the land use attorney aspect of what you do. Mm-hmm. And we have a deal now that I've been CC'd on a couple of things where I don't know how you catch these deals in this situation. You know where I'm going.
I'm lucky.
Yeah, you seem like the only lucky guy to get this type of, I don't know, it's not too prevalent that this happens, but the Lochner
yes.
Decision that impacts property. And people don't know about that. They generally don't. They don't understand it. Can you just give us a summary, a brief description of what Lochner is and what people need to look out for?
Okay. So what Lochner deals with is we take land in New Jersey. Mm-hmm. We go back, we have the municipal land use law, and prior to that there was another land use statute. I always forget the name of it. It was the back in the 1950s. It was a predecessor of the municipal land use law. Okay. And prior to that one in the 1950s, everything was defined by file maps.
Right.
So you had all your lots defined. If there was a file map and property was sold, as long as they stuck to the lot lines that were on the file map, everything was okay. You can convey the land. It was deemed an independent lot.
Right.
What happened is, after the legislation, the first land use legislation that came out, nothing really changed per se until the 1960s when the Lochner case came about. And what happened then, it was determined that if the property was an undersized lot, mm-hmm. Actually it wasn't first undersized. If the property was not subdivided from a bigger lot, and you were only conveying it to someone else, and there was common ownership. Those were the two things.
Right.
Common ownership. That the lots, I'm thinking of the name of the case.
Yeah, right. The
lots had merged, which means they became one. Even though they still had separate lot designations, they became one parcel of land.
Right.
And in order to sell off a single lot, you had to do a subdivision. Otherwise, it wasn't valid. Which is, we've dealt with it a lot because it's not necessarily a pure title issue. Right. It's more of a legal issue because it's not going to be something that shows up in land use in the land records when you check the land, the deeds and so forth in the county clerk's office.
Right.
So the Lochner case basically said that if it's an undersized lot, or if there's common ownership and it's not been subdivided.
Right.
It becomes
part of the bigger lot.
It becomes part of a bigger lot, and you have to subdivide it.
So if you have a large lot here, and George owns this one, and Bill owns this bigger piece over here, but Bill then subdivides off this piece and gives it to George, sells it to George. Now you have two parcels that George owns. But under Lochner, Now they,
Well, I'm going to circle back for a second because after Lochner, there was some other cases that trimmed it. And then in the municipal land use law in Section 7, Title 40D.
Title 40D,
Section 7. There's actually, and I pulled it. That I'm going to, if you don't mind, I'm going to read. There's one section in there, and I took the time to pull it. It's in 4055D7 in the definitions under the municipal land use law. Under the definition of a subdivision. It says, subdivision means the division of a lot, tract, or parcel of land in 2 or more lots, tracts, parcels, or other divisions of land for sale or development. The following shall not be considered subdivisions within the meaning of this act if no new streets are created. And they give you 5 categories. Number 5, I'm going to skip to that. The conveyance of one or more adjoining lots, tracts, or parcels of land owned by the same person or persons, all of which are found and certified by an administrative officer to conform to the requirements of the municipal development regulations and are shown and designated as separate lots, tracts, or parcels on a tax map or atlas of the municipality. So what that did is that made it now, if it was conforming by statute, you didn't need a subdivision.
Gotcha.
So the current version of the Lochner situation leaves it to where the lot has to be undersized and common ownership.
Yep.
And that's what we just came upon jointly not too long ago.
Well, that was even a stranger case because that's municipal land use law. And it's applying to a municipality, right?
Yes.
This one had 2 different municipalities.
Well, that was the other one crazy. Of the 2. Yeah, the one that we have recently now is in one municipality.
It's in one municipality.
And but I want to circle back to that one because what's curious, and I was involved with that matter after the purchase was over. The client came to me when the problem came up
to process the
to see what can we do.
What can you do?
He had processed the application himself. I don't know if he had another attorney. I don't remember or not. And the board deemed his application incomplete because they said the lot had merged with another lot that was adjacent to it in the next municipality over the municipal boundary line.
And he was authorized to sell it.
Exactly.
To your client.
So
which is crazy.
It got involved with us, and I'll without getting into the details of the case, to say that ultimately was amicably resolved to the satisfaction of my client. But from a legal perspective, what we were looking at is he had bought the land. It was not represented. There's a question as to the level of due diligence that may have been performed.
Sure.
And in fairness, even if it was, it doesn't mean that it would have turned up everything, because I'm not like trying to say someone didn't do the best job they could have. But maybe it could have turned up, maybe it wouldn't have, with a deeper dive. But also Oprah requests, things like that. Yeah. And those weren't done.
Non-costly little things. Talk to the municipality.
Go. The Oprah request discussed could have been finding a resolution which existed that the township, in that matter, relied on, and said there was a resolution many years earlier,
2007,
that said that these were merged and so forth, and no one ever bothered during the purchase to go do an Oprah request and look for resolutions related to the property. Yeah. And thankfully, as I said, in the end, it was able to be amicably worked out.
Right.
And the cost of litigating it, because it was a small parcel of land, it was modest.
Just not viable.
It wouldn't have, from a business standpoint, it wasn't viable. Yeah. But what's curious is, and this ties us back more towards Lochner, is in an ultimate situation like that, that could have been, and this is where you'd have to take it through the process, which would be extremely lengthy and costly, is if the applicant could have chose to litigate against the town and take a prerogative writ action on the township failing to deem the application complete and give it a hearing, or if they ultimately did and then denied him for those reasons. Either way, if he filed an action in court on a prerogative writ action against the town, against the board, once he exhausted all of his prerogative writ remedies without relief, he could have then potentially had a claim for a taking under the Fifth Amendment of the property. And there's actually a U.S. Supreme Court case from another that is grounded out of another state, but very similar facts to Lochner. And it says that you have to go through the other remedies first, such as the prerogative writ remedies first. But if you don't, it could be a taking. And basically, the Supreme Court, and I'm paraphrasing, and I'm not saying it in absolute, but generally the concept was, in that instance, the planning board should just simply give them a subdivision. Because otherwise it can be a taking, because if they're not giving them the relief and the land is rendered useless, then it could potentially be, based on the facts of a particular case, there's a possibility it could be conceived as a taking under the Fifth Amendment. So it all kind of ties in.
And the fact that this is in two different municipalities.
Yes. Now, what's curious is when I was dealing with that, in my limited research up until the time the matter got resolved, is I didn't come across any cases where the crossover in different municipalities had any impact on the issue. My sense would be it shouldn't, because property lines are property lines, and under other circumstances, as you and I both know, property lines can cross over into one town or the other, and you can have a parcel that's in both towns. So what was curious there is I could not find a case on point because, and it might have ultimately, if it went that way, had become a case of first impression, is whether, because if it was merging, well, where did it merge into which lot, which town, who got the tax money, how did they divvy it? So many open issues, exactly.
That's a case of first impression that nobody wants to take.
Thankfully, I didn't have to deal with it.
No, but the costs are...
Yes.
To even litigate that situation, I can only imagine what that could be. You're talking hundreds of thousands of dollars.
It could be, yeah.
Because of the experts alone.
Yes,
the
experts and you think about the engineering and so forth you put in to begin with. It's inexpensive, and then litigating, and it depends if you on the type of case. I don't want to say most, but a lot of, in my experience, land use cases that go on prerogative writs, there's a decent chance there's going to be an appeal.
Right. It usually is.
Not always. I don't want to say always, but
especially
a lot of times
Laurel,
there's appeals, and it goes on and on and on.
So Jay, all the litigation, all the business stuff, I'm going to make a really sharp turn left here. You're also a musician.
Well, I'm a songwriter.
You're a songwriter.
Yeah,
and you just released your first single.
First one in a long time. I've been fortunate and it came out in November. It's a song by the name of The One You Found. And I've actually, for about 2.5 to 3 years, been working with a longtime friend of mine who's these days he's in other businesses and so forth, but back in his younger years, he was a very, very good musician, guitarist. He did some songwriting on his own, played some studio work. Right. And he and I was working, and I've always been a creative writer. So, I could write brief writing, analytical, and then for fun, I can do creative writing. And I wrote some words, and it was more poetry than anything else. And I just said to him one day, I said, hey, I'm going to send these to you. Take a look at them. What do you think? And he says, I think I could do something with this. And that became the first of what we now have are actually 11 songs that have been released.
Wow.
In the past 2.5 years or so.
Good for you.
Out to the public.
Okay.
And they're available on all of the streaming apps and globally. And so I'm essentially the lyricist. He is the musical composer. And we combine our talents. And our first endeavor, we worked with a third person who was very gracious and a great help to us. And he took 4 songs into the studio and recorded them with all of his own musicians and so forth, and really did a great job producing and arranging them, and allowed us to learn the modern version of the business from him. And after that, my partner and I have basically been self-producing and arranging everything.
Nice.
In a different studio, with our own people that we're working with, our own sound engineers, and with my assistants. My partner's been doing a lot of the production and arrangements, and we've been bringing in our own musicians and singers and getting them out there. And all of our work is under the name of Project 18. Okay. If anyone's interested and wants to hear some of the songs, you can go onto Spotify or Apple Music or YouTube, anywhere where your music is, and you can find them.
So you're a dad, an attorney, businessman, songwriter, and music producer. It's pretty cool.
Yeah, I try,
You really made a good decision in saying, I'm going to do what makes me happy as opposed to what makes me wealthy. Because the happiness will lead you to the wealth. So many different people, again, they're so tunnel visioned on the dollar as opposed to it's the happiness of the work that you're doing that will reduce the dollar.
Yes.
That's what I'm teaching my kids, at least. And I think you're doing the same. And it's, well, Jay, I want to thank you for being here today.
Thank you.
It was a great learning experience for me to hear you. I'm sure everybody else who's going to watch this is going to learn a lot, from land development to personal success and overcoming challenges and putting yourself in an uncomfortable position to become successful in that uncomfortable position.
Yeah, no, I appreciate it very much. It's been a pleasure.
It's fun
to sit down with you. We've had conversations like this privately over the years, and it's fun to do it in this format and share it with all of the viewers.
You got a great story,
and
you're so full of knowledge.
And I just want to add one last thing is to any of the viewers, anyone out there, if anything that we talked about interests you or professionals, if you have a question, feel free to give me a shout. I'm always happy to talk with someone, to lend any bit of information I may have that can assist someone along the way.
It's funny, and you putting that out there is just who you are. You know what I mean? That's how you've always been. I would call you up and send people and say, "Don't talk to this client. They need somebody that can set them straight."
Yeah.
And you've done that, and I appreciate that. So again, thank you very much. Happy New Year.
Happy New Year to you and the family as well. Thank you.
Let's kill it in 2025.
Absolutely.
And let's continue to have fun.
Awesome.
Thanks a lot.
Thank you.